2019. Today I'll explain about the consumer law in Malaysia. Consumer law in Malaysia is mainly governed by the Consumer Protection Act 1999. This law protects consumers from unfair trade practices and ensures that goods and services meet acceptable standards. Under this law, consumers are entitled to implied guarantees. This means that the products must be acceptable quality, fit for their purposes, and match their descriptions even if these terms are not clearly written in the contract. Besides that, other important laws include the Sales of Goods Act 1957 and the Trade Descriptions Act 2011. These laws deal with contractual obligations and misleading representation by sellers or businesses. If consumers face problems, they may seek remedies such as repair, replacements, or refund. Consumers can also file claims through the Tribunal for Consumers Claim Malaysia, which provides a faster and cheaper alternative compared to court proceedings. However, Malaysia's consumer law is sometimes considered less comprehensive, especially regarding digital goods and the absence of a fixed short-term refund period. Historically, Malaysian consumer law developed from English common law and earlier legislation such as the Contracts Act 1950 and Sales of Goods 1957. As consumer issues increased, the government introduced the Consumer Protection Act 1999, which became the main legislation protecting consumers against unfair practices and defective goods and services. Malaysia later strengthened consumer protection through the Trade Description Act 2011 and regulations related to e-commercial and online transactions. Next, I will explain about the consumer law in the United Kingdom. Consumer law in the UK is mainly governed by the Consumer Rights Act 2015. This act provides a modern and consolidated framework by combining rules on goods, services, and digital content into one statute. This act clearly states that goods must be of satisfactory quality, fit for purpose, and as described. One important feature is the short-term right to reject, where consumers can obtain a full refund within 30 days if the goods are faulty. The law also provides a strong protection for digital products such as software and streaming services, reflecting the needs of modern economy. Enforcement in the UK is carried out through courts and regulatory bodies such as the Competition and Markets Authority. The law emphasizes fairness and transparency in contract terms. Overall, the UK consumer protection system is more detailed and consumer oriented compared to Malaysia because it provides clearer rights and stronger protections. By the historically, UK consumer law began with common law principles and laws such as the Sales of Goods Act 1893 and Sales of Goods Act 1979. Over time, stronger laws were introduced to address unfair contract terms and misleading trade practices. The major development was the Consumer Rights Act 2015, which combined various consumer laws into one act and provided clearer rights regarding goods, service, and digital content. Thank you so much. Now I'll proceed about the comparative analysis of the consumer legal framework between Malaysia and the UK. First, regarding to the implied terms and statutory guarantees, both Malaysia and the UK share similarities in ensuring that goods sold to consumer meet certain standards. Malaysia's Sales of Goods Act 1957 was largely influenced by the UK's Sales of Goods legislation, which explains why both systems contain similar impact terms. These impact terms protects consumer by ensuring that goods are of satisfactory quality, fit for purpose, and correspond with the description given by the sellers. In Malaysia, these protections can mainly be found in Consumer Protections Act 1999 and the Sales of Goods Act 1957. Meanwhile, in the UK, similar provisions are contained in the Consumer Rights Act 2015. Both legal systems emphasize consumers' rights and allow consumers to reject defective goods when the products fail to meet the requirement standards. Therefore, this demonstrates the shared legal foundation between Malaysia and the UK in protecting consumers. Next, moving on to the product liability. Both countries adopt the principle of strict liability towards defective products. In Malaysia, this is specifically provides under Part 5 of the Consumer Protection Act 1999, particularly in Section 68. Under these provisions, manufacturers or producers can be held liable for defective products that cause harm or damage to consumers. Consumers do not necessarily need to prove negligence. Similarly, in the United Kingdom, the Consumer Protections Act 1987 also imposes strict liability on producers under Sections 5 and 6. However, there is an important distinction between the two countries. In Malaysia, strict liability provisions form part of a broader consumer protection statute, whereas in the United Kingdom, the law relating to product liability is placed in a separate and more specialized statute focusing specifically on product safety. As a result, the UK frameworks appear more comprehensive and detailed in this aspect. Lastly, in terms of legislative structure, there is a significant difference between Malaysia and the United Kingdom. Malaysia Consumer Protections Framework is more fragmented because it relies on several different statutes working together. Besides the Consumer Protection Act 1999, Malaysia also used laws such as Trade Prescription Act 2011, which ensures that goods and services are described accurately and prohibits misleading representation. This approach shows that Malaysia depends on multiple specialized statutes to provide comprehensive consumer protections. In contrast, the United Kingdom has a more centralized and structured approach. Consumer rights and product safety laws are organized in a more undefined manner, making them easier to understand and enforce.
Assalamualaikum. Hello, and my name is Nurhana binti Hassan with the matric ID of EIL 242012. So, I would like to say thank you to the previous presenter. So, I will be moving on to my part, which is the legal framework of Malaysia and United Kingdom, our chosen country. So, what is exactly the legal framework of consumer protection in the context of Malaysia and United Kingdom? Before we move on to that, legal framework of consumer protection actually refers to the legislation that protects consumers in cases where imbalances occur between the traders or the offering party and consumers. The following statutes that I have chosen in Malaysia and United Kingdom actually are highlighted in their key legal mechanisms that are technically similar but overall have ultimately different structural approaches in Malaysia and United Kingdom. So there are 3 statutes each. So for the first statute is the Consumer Protection Act 1999. So Consumer Protection Act 1999 is Malaysia's key legislation for consumer protection. You could say that the Act was enacted to address unfair bargaining power between traders or marketers or manufacturers and consumers, which are most likely and most commonly are us. In the following subtopic or in today's presentation, I will be highlighting a specific aspect, which is the unfair trade practices and by extension, the consumer protection. So, as I've just mentioned, sections that I would like to highlight is actually section 8 until 16 of Consumer Protection Act 1999. So, these sections actually address unfair trading practices. So, what is unfair trading practices, you may ask? A simple example that I would like to give to our viewers is when markets or traders essentially give you false discounts. So, in the name it's false, so it's not actually there, it is fake. So, the key section that I would like to highlight is section 8 of Consumer Protection Act 1999. What does this section say? This section actually addresses that. This section is basically when consumers are falsely misled, into error. A situational example that I would like to give to you, our dear viewer, is those scratch and win price scams. So if you are not familiar with those type of scams, basically they would tell you that you have won a prize, but when you come to the point of collecting the set price, they would actually hide that price under a hidden fee that costs more than the price. So the false, misleading or deceptive conduct or the unfair trade practices in this context is the consumers believing that they have won the prize, but in truth they did not. So, moving on, you could say that through this Consumer Protection Act 1999 actually, and it's apparent in your eyes, that it has a more generalized approach in consumer protection rather than a specified approach like other statutes. Alright, so now we'll be moving on to the second statute in the Malaysian perspective, which is Sales of Goods Act 1957, or as I will refer to from now on as SOGA 1957. So, generally, this statute actually governs the sale and purchase of movable property or goods, meaning that it is something that is not immovable. So, the highlight of this statute would actually be upon the implied terms in relation to the state of goods. Alright, so moving on to part of the statute itself, the key factors of aforementioned or the key sections of aforementioned actually lie in section 14 until 17 of SOGA 1957. Alright, so what does this mean? So sections actually describe the implied terms on the movable property. They are automatically applied unless it is explicitly removed or excluded by the involving contractors. So, a particular section that I would like to highlight for today in terms of SOGA is section 15 of Sales of Goods Act 1957. So what does this section detail? This section actually details that goods must match the description. So to make our beloved viewer understand the context of this is, let's say that you are purchasing a grade A or a high grade honey, raw and nothing else mixed into it. However, when the product actually arrives with it, you realize that it is actually a low grade honey mixed with other substances of liquid like corn syrup. So this in itself, the latter half, is actually a breach of section 15 of SOGA 1957. So, everyone can see here that the focus of SOGA 1957 generally is to protect consumers involving goods, relying on obligations between contractors and consumers. And lastly, as I must emphasize again, it is only on movable property or goods. So in this context, it is in that law. So furthermore, moving on to the third and final statute in Malaysia's context of legal framework of consumer protection is the TDA 2011 or Trade Descriptions Act 2011. So what does this statute actually entail? This statute mainly ensures fair trade and accurate representations of product information. So simply, it indicates that whatever information that consumers receive regarding products relating to goods must be accurate. So the focus of this statute in the context of today's presentation would be on the regulation of false trade description and misleading representations. Alright, so we will be now moving on to the sections that I have chosen for this subtopic. So there are two sections that I've highlighted. Before we move on to that, I would just like to describe that this Act's applicability also extends to online platforms. So, as I just mentioned regarding the two sections, we would like to first begin with Section 5 of Trading and Trade Descriptions Act 2011, so, which is Section 5. So what is Section 5, you may ask, dear viewer? Section 5 is actually the prohibition of trade descriptions that are false. So I will give you a simple example to understand this, so you don't have any more confusion. Let's say that you buy a product and the product says it is made in America, but actually the product is being made in China. That is false trade description, and it is prohibited under Section 5 of Trade Descriptions Act 2011. So, moving on to the second section of TDA 2011 is Section 29. So what does Section 29 detail? Section 29 actually regulates the certification marks like halal logos. So, now we will think back about how Malaysia's population is highly dense with Muslims. So you could say that this is particularly important to the likes of us. So, let's just say that authorities can simply set standards in having whatever that must be done in order to achieve this halal logo. So, all in all, you could see that TDA 2011 actually ensures that product-related information that consumers receive are accurate. Why? Because consumers rely on these trade descriptions to buy the products. So that is the importance of this act. And seeing that we have already done with the Malaysian context of legal frameworks, we will now be moving on to the UK or United Kingdom perspective of consumer protection. So I would just like to first begin with the Consumer Rights Act 2015. So the Consumer Rights Act 2015 is a unified and a consolidated legislation of consumer protection in the UK context. So what does this mean? It is consolidated in the sense that it covers goods, services, and also unique digital content that is explicitly covered. I mean content. So the focus of this statute would actually lie upon the consolidated nature of this legal framework. So this act is generally applicable to consumers and traders, similarly to Consumer Protection Act 1999 in the Malaysian context. So notable sections to highlight is actually Section 33 to Section 47. So what does this section or dedicated chapter actually detail? It actually details that the traditional implied terms applied to movable property like merchantable quality, descriptions, so on and so forth, actually be also explicitly applied to digital content. So you may be confused on what I am talking about. So I'll just give you a quick example. So under Section 34 of Consumer Rights Act 2015, let's say that you or maybe your son has bought a game. So this game consistently has bugs, meaning that it crashes or it is generally becomes unusable, but it is in a digital context. So section 24 says that if you fail the merchantable quality test, or generally in simple terms the satisfactory test, for this to perform in a good way. So these aforementioned sections, or like the section that I have just mentioned, display United Kingdom's modernization. In the sense, it extends the traditional implied terms that are applied to physical movable property also be applied to digital goods. So this is what I meant by the focus of this particular statute. Moving on to the second statute of the UK context of consumer protection is Consumer Protection Act 1987 or CPA 1987. So what does this statute establish? It actually establishes product safety in relating to defective goods, emphasize on defective goods. So in what context does this defective goods have to do? You could say that it is specialized towards goods that compromise consumer safety. So it is not just goods, it is dangerous goods. So strict liability is introduced to safeguard consumers. So in relating to today's presentation, or this particular subtopic concerning this statute, is the previous idea that I have just mentioned. Alright, so on to the statute, I've actually focused on two sections. So we will be beginning with section 2. So section 2 particularly discusses the applicability of dangerous or defective goods. It is basically when a product is defective, and product, quote unquote, applies to most goods excluding immovable property. So immovable property is not included in this particular section. So strict liability applies against manufacturers when defects are related in causing damage. So meaning for strict liability or complete liability applying to manufacturers must only be when the product itself has to do with the injury caused. These injuries are listed under section 5 of CPA 1987, which, for example, I may include personal injury or even death. Alright, so we will now be starting on the final statute in the context of United Kingdom for the legal framework concerning consumers. So, the last statute is called Digital Markets Competition and Consumers Act 2024, or as I would like to call it moving forward, DMCCA 2024. So, this act actually updates previous consumer laws related, such as CPUTR 2008, and enhance the related enforcement powers. So, the main focus of this statute in relation to today's presentation is actually one thing that I would like to focus on, which is protection of consumers against unfair trading practices in the online commercial scene. So, now moving on to the part that I have just mentioned, the sections that I've actually highlighted are quite general. It is actually from section 224 and section 230. However, to give our viewer a better understanding of what I am trying to say, I've particularly highlighted section 225. So what is this section actually talking about? It talks about unfair practice in the context of what this statute actually protects is, say a company ignores consumers' complaints regarding their company in an online format. So that is the digital context that I am talking about. Alright, so in addition, it's actually Schedule 20 of this particular statute. It actually says that fake reviews are actually prohibited under the DMCCA 2024, showing that the United Kingdom has actually modernized the protection. With continuously growing unfair practices, it actually protects consumers against these progressively modernizing unfair conduct. So, related to this statute itself, as I have mentioned earlier about the enhancing empowering the enforcement powers, is actually apparent in the CMA powers in the UK context. So CMA is actually meaning Commercial Market Authority. So through the updated legislation, it allows CMA to directly enforce their powers through fines, for example, without having to go through the extensive court procedures.
Assalamualaikum and good day everyone. My name is Nohamiza with matric ID 241040. Today I will present about consumer rights in Malaysia and the United Kingdom. So consumer rights are important because they protect buyers from unfair business practice and ensure consumers receive safe and quality goods and services. Malaysia mainly used the Consumer Protection Act 1999, while the United Kingdom used the Consumer Rights Act 2015. So for this part, I will explain about consumer rights in Malaysia. So consumer rights are protected under the Consumer Protection Act 1919 or CPA 1919. The Act protects consumers in many areas such as safety information, quality of goods, and remedies. Some important rights include right to safety, right to information, right to good of acceptable quality, right to fitness for purpose, right to redress. Right to safety in Malaysia under Section 19 under 21 of the CPA 1999. Consumers have the right to safety. This means goods and services sold in the market must meet safety standards and should not harm consumers. Suppliers are prohibited from selling dangerous products, even if no specific safety standard exists. Suppliers still have a general duty to ensure products are safe. Right to information in Malaysia, Section 9 and 10 protect consumers from false or misleading information. Businesses cannot make deceptive advertisements or false claims about their product. Consumers must receive accurate information so they can make informed decisions. Quality and fitness of goods in Malaysia, Section 32 states that goods must be of acceptable quality. This means products should be safe, durable, and free from defect. Section 33 provides the right to fitness for purpose if consumer inform seller about the purpose of the product. The product must be acceptable for that purpose. Section 34 also ensures goods must match the description given by the seller. Other rights in Malaysia also protect consumers through fair contract terms under Part 11A, right to redress through the Tribunal for Consumer Claim, right to consumer education. The tribunal helps consumers settle disputes quickly and at a lower cost compared to courts. I will explain about the consumer rights in the United Kingdom. In the United Kingdom, consumer rights are protected under the Consumer Rights Act 2015 or CRA 2015. The UK law is considered more modern and comprehensive because it includes protection for digital content such as software, games, and e-books. So, the main consumer right in the UK provides several important rights, including goods must be of satisfactory quality, goods must be fit for purpose, goods must match their description, protection for digital content, protection from unfair contract terms. The Act also ensures service must be carried out with reasonable care and skill. Right to enforce consumer rights in the UK. One special feature in the UK is the system of tiered remedies. Consumers have 13 days to reject defective goods and get a full refund, right to repair or replacement after 13 days. This gives consumers a clearer step-by-step remedy process. The cooperation between Malaysia and UK. Both Malaysia and the UK protect important consumer rights such as safety, information, and fairness. However, the UK law is more advanced because it covers digital content. It provide clearer remedies. It has stronger protection against unfair terms. Malaysia still has strong protection, but improvement can be made, especially regarding digital consumer rights. In conclusion, consumer rights are essential to protect consumers and ensure fairness in the market. Malaysia and the UK both provide legal protection for consumers, but the UK system is more detailed and modern. Malaysia can improve its law by strengthening digital consumer protection and introducing clearer remedies. That's all for my part. Thank you.
Assalamualaikum. My name is Azisha Nuriwana with the metric ID DIL 242014. Thank you to the previous presenter. Now I'll be presenting on remedies and redress mechanism available to consumers in Malaysia and United Kingdom, as well as the comparative analysis between both systems. Alright, so firstly, in Malaysia, consumer remedies are mainly governed by the Consumer Protection Act or CPA 1999. Under sections 40 to 43, consumers are entitled to remedies when their goods fail to comply with implied guarantees such as fitness for purpose, and acceptable quality, and compliance with description. So now let's go through each of these sections one by one. Firstly is section 41, subsection 1, paragraph A, allows consumer to require the supplier to remedy a failure within a reasonable time if the defect is one that can be fixed. For example, you bought a new washing machine, but it has a faulty button, but it can still function properly, then you as a consumer may demand the supplier to remedy the issue. Furthermore, section 43 provides that if the supplier refuses or fails to do so, then you as a consumer may have it repaired elsewhere at the supplier's expense or reject the washing machine entirely. Meanwhile, section 42 gives the consumer the right to reject the goods with serious defects, including with a request for a refund or replacement. For instance, if a newly bought car suddenly catches fire due to a manufacturing defect, you as a consumer may reject the vehicles because the defect of the vehicle is very substantive and dangerous. In addition, section 43 enables consumer to claim damages for any loss suffered due to a defective goods. For instance, if a defective electrical appliance causes a house fire and damages the consumer's property, then you as a consumer may claim compensation for the loss suffered. Apart from substantive remedies, Malaysia also offers a statutory redress mechanism through Tribunal Consumer Claims Malaysia, which established under Part 12 of the CPA. The tribunal offers a faster, cheaper, and less formal method of resolving disputes without going through a lengthy court procedures. This demonstrates that Malaysia emphasizes accessibility and flexibility in consumer protection. The case of Matang Plastic and Metal Work Industries Sdn Bhd and others, and Daimler Chrysler Malaysia Sdn Bhd and others supports this provision because the court found that the vehicle was unsafe, defective, and not of acceptable quality, which amounted to a breach of implied guarantees under Section 32, Subsection 2, Paragraph A of the CPA 1999. Since there was a breach of a statutory guarantee, the consumers became entitled to the remedies under Sections 40 to 43 of the Act, including repair, replacement, and compensation for the losses suffered as a result of the defective vehicle. Moving on to United Kingdom, consumer remedies are governed by the Consumer Rights Act 2015. Unlike Malaysia, the United Kingdom adopts a more structured and systematic approach. Specifically, under sections 23 and 24, if consumer fails to exercise their short-term right to reject the goods within the prescribed period, which is 30 days, the consumer must follow a sequence of remedies beginning with repair or replacement. If these remedies are unsuccessful, then the consumers may seek a price reduction or exercise the final right to reject the goods. For services, sections 55 and 56 provides remedies such as repeat performance and price reduction where the services are not carried out with reasonable care and skill. For example, if a consumer hires a contractor to install a kitchen cabinet, but the cabinet was installed improperly and became loose after a few days, then the consumer may require the contractor to perform the service again under section 55. However, if the repeat performance is impossible or cannot be carried out within a reasonable time, the consumer may instead claim a price reduction under section 56. Besides statutory remedies, consumer protection in the UK is also strengthened through enforcement bodies such as Competition and Market Authority, alerts, ageism, and ombudsman schemes. This shows that the UK
So for this part, I will explain the dispute resolution mechanism in Malaysia and the United Kingdom. Dispute resolution in Malaysia, consumer disputes are mainly resolved through the Tribunal for Consumer Claim Malaysia or TTPM. The tribunal is established under Part XII of the Consumer Protection Act 1999. The TTPM provides a quick process, low-cost claim, easy procedure for consumer. Consumer only need to pay RM5 to file a claim. One important feature is that lawyers are generally not allowed under Section 108 of the CPA 1999. This means both parties present their cases themselves without complicated legal language. The tribunal can hear claim up to RM15K. It also encourage negotiation and settlement before making a final decision. Overall, Malaysia focused on speed, affordability, simplicity. Next, I will explain dispute resolution in the United Kingdom. In the United Kingdom, the dispute resolution system is more detailed and multi-layered. Consumers are first encouraged to use alternative dispute resolution or ADR methods such as mediation, ombudsman service. These methods help resolve dispute without going to court. UK court and enforcement system. If ADR is unsuccessful, consumer may bring the case to the country court through the small claim track. The UK also strengthened enforcement through the Digital Market Competition and Consumer Act 2024. They give power to the Competition and Market Authority or CMA to take action against unfair business practice. The CMA can impose penalty without long court procedure. So for the comparative analysis, Malaysia uses a centralized tribunal system that is simple, fast, and consumer-friendly. However, it is limited to claims below RM15K. Meanwhile, the UK system is more comprehensive and systematic because it involves internal complaints, ADR or ombudsman, small claim court, administrative enforcement by the CMA. The UK system provides more layers of protection but is more complex compared to Malaysia. In conclusion, both Malaysia and the United Kingdom provide effective dispute resolution system for consumer. Malaysia emphasizes simplicity and affordability through the DTPM, while the UK provides a more modern and multi-level approach using ADR courts and enforcement authority. That's all for my part. I pass to the next presentation.
Alright, so now let's move on to the cases in Malaysia and also in the United Kingdom about how well they protect their consumers. So now let us start with the cases in Malaysia, starting off strong with the case of Mata Plastic and Metalwork Industries Sdn Bhd and others, and Daimler Chrysler Malaysia Sdn Bhd and others. So what happened in this case is actually when the first appellant purchased a second-hand car, a Mercedes-Benz, for more than 500,000 ringgit after being assured by the respondents that the car was safe, high quality, luxurious, and free from any kind of defects. It also mentioned that the car was serviced only at the authorized workshop and was never been modified before. However, within a short period of time, the car experienced several breakdowns and needed to be repaired for many times. Eventually, while being driven on the Penang Bridge, the smoke came out from the air conditioning vent before the car caught fire and almost completely destroyed everything. After this incident, the first appellant, unsatisfied with their purchase, brought an action against the respondents for misrepresentation, breach or implied guarantees, and also negligence under Consumer Protection Act 1999. So then, the Court of Appeal found sufficient evidence of misrepresentation by the respondents to the appellant since the car was not